substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier
yes,
which were using the expression university,
yes,
though they were not covered. They were not.
So you are given 2 years.
You are given. It's a sunset clause.
Absolutely.
You're given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted under an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution.
Exactly.
Those laws all continued post-independence.
Yes.
So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees.
Yes.
That's how they acquire the right. But your argument is without this, they wouldn't have had that opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But Manoj, the point really is, and this is a different point, and this really tells your lordship the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906. It comes from 1906 because education is an occupation. You cannot, in an occupation, do what you like.
That regulation may also be traceable to 30. For instance, in the context of Article 301 of the Constitution, which is in Part 13.
But that's on trade.
That's on trade. But our court said that regulatory measures which facilitate trade are permissible under 301.
But this point was dealt with in TMA-PI. The TMA-PI said, no, it is occupation. It's not charity. It's occupation, but the surplus that you make when you run an institution must be plowed back into the institution.
Actually, it may not arise here. All that we are saying is that the power to make regulations, though expressly referable to 1906, is also implicit in 30 because 30, our court has said, 30, though absolute, cannot preclude the parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
institution. That's under 1906, Madhur.
As an institution of excellence.
But Madhur, that's under 1906. TMA-PI says that also. That regulation is under 1906. That's why, Madhur, the absolute right is there, but the absolute right has to be regulated by standards.
Yes.
The absolute right is of the choice. Means I can set up a school. The school will be regulated by the education.
That point you made yesterday, that you can set up a primary school, a secondary school, a high school, an intermediate college, a degree college. Or
that's the choice. That's the choice. Now,
because a university is also an educational institution within the meaning of Article 30.
Yes. So therefore, but that choice can't be so absolute that you can do what you like. So you have to be You have to standardize your education in terms of the general standards set for all other educational institutions by the majority community or any other community.
And your argument really is this, which we'll hear the other side on, that if you apply the expression administer in a very strict sense, namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Manoj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education, it need not be only, but St. Stephen's had only 6% minority students at one point in time. Only 6%. Increased to 14% at some point in time. And then this court said in St. Stephen's, in TMA-PI, it can go up to 50%. It need not have said so. That's why our Kerala education bill is sprinkling of minorities.
Also, one very important circumstance, you can't read Article 13.
Outsiders. That's correct. No, sprinkling of outsiders. Yeah, so therefore you could have outsiders, you will not destroy your minority status.
The object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration. It doesn't detract from your character as a minority.
That's the point I was trying to make yesterday. Now, Manoj, in this university, just to get the facts right, Manoj, there are several departments that are run. For example, All India Council for Technical Education. We have to go to them for recognition.
For medical college, you go to the...
For medical college, you go there. For the dental
Architects,
council, we go there. For
the
pharmacy,
architects.
we go there. For National Council for Teacher Education, we go there.
The law college will be governed by the bar council.
Correct, bar council. And there are different elements of administration in that. In a medical council, how will we administer at the university? We will not have any expertise. So we'll get outsiders to do it. Kindly see, the impact of administration is again my choice. I hope, Malad, I'm making myself clear. In some of these technical things, we'll have no knowledge, especially in a medical college. So we'll get people from outside and say, you please help us in doing this. And they may be in majority. But the choice is that I will say, please come. That doesn't destroy the character of my institution. So different standards will apply to different disciplines depending on the nature of the course that I am teaching. It is true of engineering as well.
The only difference here, we'll consider it. I mean, I'm not putting it as something against you, but a factor to be considered is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
That's all right. But I can challenge it. Let's put it this way.
Does that alter the...
No. I can challenge it, Malas. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malas, we are not here dealing with the administration. This, Malas, please appreciate, Basha never dealt with administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute. And therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that, Malas. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution, because the administration is
established and administered disjunctively.
That was the
argument.
That was rejected in Basha. That was rejected in Basha.
There can't be any doubt that it's established and
administered.
You can't read that and as or.
So therefore,
you have not. Dr. Dhawan has also not argued
and
that.
Therefore, overwhelming participation of others in the administration, even if they are in a majority, even if by statute, will not destroy the character of the university. Because if I feel that my right is being impeded, I can challenge it. But I'm not. And the fact of the matter is, Malas, if your lordship looks at the structure, and you need not in this case, because we are not dealing with that. In fact, it was overwhelmingly Muslim despite the statute. De facto. But we don't have to go into that, Malas. We can't in a reference go beyond what your lordships are asked to decide. So, Malas, therefore, now I was trying to show, Malas, that all these regulations fall under 1906. The genesis and the conceptual constitutional genesis is you can't have institutions in the country without standardization in the field of education. And that standardization can only be provided by law under 19. And the law will apply to majority institutions and to minority institutions. And UGC and all other statutes are consistent with 19. The right under 30 is absolute, the choice, but the regulation is to be done under a law by Parliament under 1906. That's Malas, the submission and the interplay of 1906 with Article 31 of the Constitution. Now, Malas, which page is?
417.
The context of what my lord has put in, my lord the Chief Justice. Kindly note, Malas, I won't read it. Kindly note, Malas, volume 5A, PDF 417, paragraph 41 of St. Stephen's. Volume 5A, PDF 417, paragraph 41 of St. Stephen's. And I'll read that sentence to you. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. That doesn't limit it to the minority. This is 5A, PDF 417, paragraph 41. This sentence is between placetum G and placetum H.
Page number?
417, volume 5A. It's between G and H, which says exactly what I'm trying to, let's say, consistent with my submission before your lordships.
Actually, therefore, it's important to clear a cobweb, which is that Article 30 does not mandate that administration must be only by the minority itself.
That's correct.
In the sense that the personnel who administer are not required by Article 30 to belong to the minority itself.
Exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer
That's correct.
in a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
Just to give an example, Mullah, that I am myself experienced, I happened to be in the governing body of St. Stephen's at one point in time, Mullah. Most of it were non-minority people.
The essential element of Article 30 is the conferment of choice on the minority.
That's correct. That's correct. So we are missing the link, Mullah.
It can't be read in the reverse to impose an embargo that you will not have anybody save your community.
Well, the minority will not have the expertise to run the institution, many of these institutions. Will not have. For force, we'll have to take people from outside. That's why St. Stephen says, have faith and founders in whom the founders have faith and confidence. I have confidence in 10 people in the majority community to run my institution. I'll give it to them to run it. Doesn't make the institution a non-minority institution because it is founded by the minority. The inspiration to set up an institution is that of the minority. The steps taken to set up the institution is of the minority. The persuasion done by the institution to the government and the authorities is by the minority. So as long as these elements are satisfied, it's founded by the minority.
Can you come again on that? The inspiration to set up...
The inspiration to set up the institution is by the minority. The steps taken for persuasion are by the minority. The essential paraphernalia of initial funding by the minority. Persuading the authorities to accept that fact by the minority. And all these elements are satisfied in this case. So the genesis of the institution is the test. That is antecedent to recognition. All that is antecedent to recognition. And Basha says, because you are incorporated, you have lost the status of a minority. This is the problem. This is the problem with Basha. And remember, Malats, when Basha was decided in 68, in-ray education bill was already there. Not referred to in Basha.
It is referred to.
Not dealt with. Siddhaj Bhai. Dealt with also. Siddhaj Bhai already there. And of course, now we have TMA Pi and other issues, other judgments. So the interplay of 1906 is fundamental. Now, Malats, Now, as Council for Architecture, we have people giving degrees in architecture. We don't have Muslim community people in architecture. Enough. Anyway, so I'm done with this part.
Now, what remains, Dr. Mr. Sibal, what
I've
remains?
already said that it glossed over, yes.
What remains now, Mr.
Now,
Sibal?
how the reference came is very important, Malas. I'll just give your lordships that. Now, Malas, as your lordship knows, give me that note. And I'm just giving you.
Mr. Sibal, you're quite proficient from where you began last year on your laptop.
No, I'm very
on your
proficient,
iPad-
Malas.
on your
Now I'm
iPad.
completely, it's just that it'll be quicker if she does it than I, Malas, do it. No, I do
But
it.
Dr. Dhawan, you have not made any progression at all on that. Just,
No,
I must also tell you that there's a world of literature which opens up when you use your iPad, which
Absolutely,
is so, you know,
absolutely. Yeah. Not just,
forget all this,
there's also a world of abuse that opens up.
of course.
We have to suffer,
I'm
get enriched by one
I'm
and suffer the
resisting
other.
myself from agreeing with Mr. Sibal.